All right, can I have the parties on Johnny Pete Clark, please? All right, the court is calling 2022 CR 1898, State of Texas versus Johnny Pete Clark. Can I have parties announced for the record for the state,
Brian Grimmer for the state of Texas.
for the defense?
Scott Martinez.
All right, and are you Mr. Clark?
Yes, Judge.
All right, I'm gonna make sure you speak up so that the court reporter can hear.
Yes, Judge.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Clark, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, Judge.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Mr. Clark, I'm showing you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it, and did you sign it in all the appropriate places?
Yes, Judge.
All right, did you understand that what you're charged with is unauthorized use of a vehicle? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes, Judge.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Judge.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Judge.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Judge.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Judge.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Clark, has anyone threatened, coerced you, or placed you in fear to get you to enter this plea?
No, Judge.
Has anyone promised you anything other than a plea bargain agreement to get you to enter this plea?
No, Judge.
Are you satisfied with the way you've been represented?
Yes, Judge.
Are you a U.S. citizen?
Yes, Judge.
Court will find that defendant has knowingly and voluntarily waived his right to trial. Showing you what's entitled plea bargain page. Did you review that page with your attorney? Did you understand that?
Yes, Judge.
According to the plea bargain agreement, punishment is to be assessed at 9 months in the state jail facility. There's a $500 fine. There are no applications, and there's to be restitution of $500 to Pedro Lerma, Lerma. Did you understand that to be the plea bargain agreement?
Yes, Judge.
Defense, is that the plea bargain agreement?
Yes, Judge.
State, is that the plea bargain agreement?
It is, Judge.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it, and did you electronically sign it? And I'm sorry, did you sign it in both places?
Yes, Judge.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Judge.
Counsel, are there any such motions?
No, Judge.
Then to the offense is charged in indictment. How do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Judge. State offered state's exhibit number 1.
Any objection?
No objection,
Mr.
Judge.
Clark, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it, and did you sign it in all the appropriate places?
Yes, Judge.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Judge.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Judge.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulation. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits one and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with anything?
Yes, Judge.
Anything you wish to say on behalf of your client?
Just that the court followed the plea bargain agreement and I must stay jail, Judge.
All right. And is he still on parole?
I don't believe so, Judge.
All right, and the court will sentence you to 9 months in the state jail facility. There's a $500 fine, time and money run concurrent. Give you credit for your time served, and this will be restitution of $500 to Pedro Loma. Finally, what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, Judge.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Judge.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, Judge.
If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. Do you understand?
Yes, Judge.
All right, good luck to you, Mr. Clark. We're off the record. You can give this to your client. Mr. Clark, you're gonna have to start making better decisions. Otherwise, you're gonna find yourself in and out of prisons. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
All right, so on Germanic Williams or Kenneth Williams or,
Okay, is there a lot of them in the trial?
they're saying that they're proceeding on Mr. TOUSSAINT. Is that correct?
Yes, sir.
All right, Mr. TOUSSAINT, are you requesting a jury trial?
Yes, Your
All right, thank you. So we'll be proceeding on Mr. TOUSSAINT. Could I have the file on Alvarado, please? All right, Ms. Ferguson, when are we calling Mr. Alvarado back?
Next week. Tony on set will be available.
All right, so what date?
The second jury on the 17th, if you want to bring it back on the 16th. just to-
Yes. All right, Mr. Alvarado, we're gonna bring you back on May 16th, and you'll need to give him a reset form, Ms. Ferguson.
And then-
All right, you can make sure Mr. Alvarado signs that, Ms. Ferguson. Oh, I'm sorry, could I have the Alvarado file, what, please? And then what date are we doing Germanic or Germanic Williams?
The 17th, Judge,
17th of what?
of May.
That's next Tuesday, Judge. I've been noticed for it.
Okay, just 1 second. Do you want to speak with your client?
No, I've talked to him 100 times, Judge.
All right, you can let Mr. Williams go then.
Thank you.
Excuse me, Your Honor.
Yes. All right, and when are we setting, I have a file for Daniel Jacob, that's the 27th. I don't know why I put that back. And then Della Riva, May 20, June 27th. All right, and who are you here for?
Tell Your Honor.
Della Riva, can you give him, Ms. Ferguson will give you the reset form on Della
Thank you.
Riva. Do you have all the jurors?
We don't know, Judge.
Okay.
Is it just, maybe I just kind of put everybody in line. I know that I spoke Mr. C The one that was, what's his name? It's number, juror number 66.
Judge, can I see the PowerPoint will work? I know we have some tech issues.
Juror number 66 is the one that I informed you, Judge, this morning. What do you need?
Can you just go on the PowerPoint? Okay, thank you. Well, you know, we have that technical issue where they're underneath the table and it's like the switch is bad.
Could I have a file on Mr. Otis Toussaint, please? All right, so this is state jail felony.
Yes, Judge.
All right, and Mr. Locke is your client. If he were to be found guilty, I'm not saying he will, but if he were to be found guilty, is he coming to the court?
Yes, he is.
All
The
right,
judge for punishment.
okay. All right, before we bring the jury in, I'm just going to take announcements. Court is calling 2021 CR 2505, State of Texas versus Otis Earl George Toussaint. Can I have parties announced for the record for the state?
Michael Villarreal, Michelle Hayden for the state.
Shannon Locke for Otis Toussaint and Kim Gonzalez for Otis Toussaint.
All right. And it is the court's understanding that if the defendant were to be found guilty, then he would come to the court for punishment. Is that correct?
That's correct, Your Honor.
And has that document already been signed?
So, yes, Your Honor.
With regards to discovery, the court is in receipt and it's in the court's file, a discovery acknowledgement that was completed on November 10th, 2021. Defense, have you received all the discovery?
There's going to be an update to that, but previously tendered prior to today. There were some orders that were turned over after that, and it should updated discovery acknowledgement. Prior to bringing the jury.
So defense, do you have all the discovery? That's either yes or no.
I believe that there is items that the state had in its possession that are no longer part of the file. They've turned over everything that they have in their file.
Okay, what do you mean that they have something in their possession that
Well,
is no longer in their file?
So for instance, Your Honor, there was body cam that was not part of the state's file. That police reported to the home of Mr. Toussaint. According to the reports, they had body cam, but there's never been any body cam turned over. We're ready for trial, Judge.
There's body cam in the file. I was almost certain it was in discovery. It's been in the file for as long as I've had the file.
Okay.
I've not seen that body cam.
Well, has the body camera video been in the file?
Yes.
Okay, and has the defense had access to it?
He's had our file previous setting was down here, and it's as well as been down here up this morning.
All right, now with regards to juror number 66, juror number 66 is excused by the court due to medical issues, due to an exposure, so that juror is not here. Any objection from the state?
None. Oh, yeah.
Defense?
None from the defense, Your Honor.
All right, are both parties ready to proceed?
State's ready.
Defense is ready, Your Honor.
Do you have all the jurors, Deputy Laura?
We have most of them. I'm not sure who never came
All right, so how many are we waiting on?
back. Maybe 1 or 2.
All right, which 1 or 2 are we waiting on?
19.
19 and 63?
They should be here. They said they were done the hall.
Okay. All right, everyone, we're gonna give them a few moments and then we will proceed.
Once we get a break. Shannon, I can get you. So I told you about it. I think, topic for you.
All right, how much time are you all asking for voir dire?
So how does the court do it? General voir dire and then individual?
Yes, how much time, before I say that, how much time are you all asking for?
That's 30 minutes.
That's fine, Your Honor.
All right, so 30 minutes each. Then what we can do, because normally, Mr. Lott, well, not normally, we decided to change it up a little bit because it gives Brenna a break. We normally do 30 minutes, and then 30 minutes, 30 minutes. But since you all are both saying you only need 30 minutes each, what we will do is each side will go for 30 minutes. And you can do specific and general at the same time, do the voir dire however you choose to do it.
Okay, and then, so then does the court require us to bring people up individually after?
No, we do not bring people up individually afterwards. What ends up happening with strikes, if you have strikes, you don't have to do that in front of the jurors. The jurors will be excused. You and the state can see what you all agree on, and those you do not agree on, then I will make the decision.
Okay.
But we don't bring
You
people
can
up.
bring
for
people up
that.
to ask
No.
these specific questions. Okay. Well, then maybe a little bit longer, Judge.
Because otherwise, if I bring people up individually,
I understand.
then,
I get it.
okay.
But could we get an hour then for voir dire? Side?
Do you really need an hour? It's a state jail felony.
Well, it's I mean, so, I mean, Mr.
I'll
Toussaint.
give each side 40 minutes.
Thank you.
It's still just all together. correct?
Yes.
Thank you, Judge.
For now, you okay with doing it that way?
Yes.
All right, everyone, I'm going to take short
No, it's fine. There's some spaces where people are missing.
All right, everyone, please be seated. All right, everyone, good afternoon. There's usually a response that goes with that. Good afternoon, everyone. All right, welcome to the 187 District Court. You're in the 187 District Court on the 4th floor. So which courtroom are we in? All right, and I'm Judge Boyd. And so who is the judge in the 187? And you're probably asking yourself, why is she asking us that? And the reason why I'm asking you that is because we can't begin unless you all are here. And you will be shocked how many people forget that they are in what court? What floor? Which judge? They forget that. And so what we discovered is sometimes we've been missing someone and they're on a panel down the hallway and they don't realize they're in a different court, which throws everything off. So I'm always, you can remember any of those. I'm the only Judge Boyd in the courthouse and there's only 187. So I'm hoping you'll remember either one of those things if you get lost or if you end up on a different jury. You will say, I don't belong here. This is not the 187. So you all have some expensive items in your hand, and those are those cards. So is everyone able to raise those cards? Awesome. Okay, you can lower them. This is the reason why I asked that, is because this process is called voir dire or jury selection. And there are going to be questions that's going to be asked of you. And there are sometimes there's going to be a question and you're going to want to respond to it. So before you respond, I'll need you to raise your number and be acknowledged by whoever is asking you that question. And then you'll be able to speak. The reason why, to my right, we have our court reporter, Brenna DeMoss. I think she's excellent at what she does. I think she can take down 3 people speaking at once, but it's very difficult for her to do that. So in order that her job is easier, we only speak 1 person at a time so she can make sure she takes it down because she has to take down everything that all of us are saying. The other thing is I'm going to need everyone to make sure you speak up because it will make it easier for her to hear and easier for her to take down everything that is being said. So I always tell every jury panel that comes up to this court, I always give them these instructions. I've only had 2 panels to be able to follow this instruction. So this is your test. Whenever you are speaking, if you're in the jury box, you can remain seated when you speak because Brenna will be able to hear you. I will be able to hear you. If you're on this first row right here, if you remain seated, I will be able to hear you when you speak and Brenna will be able to hear you. Everybody else, because of the way the acoustics are in the courtroom, if you remain seated, we will not be able to hear you. And people are going to start saying, could you speak up? Could you speak up? Could you speak up? And it's the same thing for the state and the defense. When you're speaking to someone in the audience, if you can make sure that you're not blocking them so that Brenna can hear. So does everyone understand those short rules?
Yes.
All right, so I've already introduced myself. The case before you today is State of Texas versus OTIS TOUSSAINT. I'm going to have the parties introduce themselves to you. For the state.
Good afternoon, Michelle Hayden.
And for the defense.
Good afternoon, Shannon Locke for OTIS TOUSSAINT.
Hi, good afternoon, I'm Kate Gonzalez.
And Mr. Toussaint, if you can introduce yourself to the jurors, please.
Good afternoon, everyone. My name is OTIS TOUSSAINT. Nice to meet everyone.
All right, I've been mispronouncing it.
TOUSSAINT or TOUSSAINT, man.
Okay, thank you.
Either way.
All right, so the charge in this case is interference with child custody. Both the state and the defense is probably going to be speaking to you more about that. This is what I want you all to remember. When the state or the defense or myself are talking to you, they're all hypotheticals. And if you have shades on, you're gonna need to take those off. All right. So when the state or the defense or myself are talking to you, we're not talking about this specific case. We are talking about hypotheticals. So just remember, the state nor the defense can talk to you about the facts of this case. The only time you will learn about the facts of this case is if you are on the jury. Does everyone understand?
Yes.
Let the cards. See, I'm practicing you with the cards. Yes, okay. All right, so I want to talk to you about an indictment. How many people have heard of the word indictment before? All right, great. I see a lot of people are watching television are involved in the system or no attorneys. Well, an indictment is just the way by which someone is brought to court. And an indictment is to tell somebody what they're charged with and where they're supposed to appear. Now, some of you may not want to raise your hand for this question, but just raise your hand if it applies to you. How many people are here have ever had a traffic ticket? All right, I see there's some people who haven't had any. That's nice. I've only had one. But when I first got that traffic ticket, that was back in the day where they gave you a piece of paper. They still had to flip things. They don't do that now, my understanding is electronically. So I'm not going to talk about my ticket. Here's a hypothetical. So let's say you're not wearing a seat belt, or let's say they say that you didn't follow the stop sign. You just use it as a yield sign instead of a stop sign. And they give you a ticket and you sign for that ticket. You signing for that ticket is not you saying, I'm guilty, I did it. That ticket is just to tell you, this is what I'm pulling you over for. And this is the courtroom where you need to appear to answer the fact that I'm saying you ran a stop sign or you ran a red light or you're not wearing your seatbelt. So it doesn't mean that you're guilty or that you did it. Does everyone understand that?
Yes.
All right. So an indictment is the same thing. An indictment doesn't mean that someone is guilty. It's just a way by which they're brought to court. So does everyone understand that?
Yes.
Now, the law is you cannot hold it against Mr. TOUSSAINT because he's been indicted for this offense. Does everyone understand?
Yes.
All right, is there anyone who's going to hold it against him because he's been indicted?
No.
All right. Now, I'm old, so number 19 is like, no, you're not. Oh, yes. How many of you all, let me tell you how old I am. How many of y'all have seen Barnaby Jones or Mannix? See, if you look around number 19, there are only a few of us who've seen that. So how many of you all have heard the term right to remain silent? Is there anyone who hasn't heard that term? So our law says that you don't have to testify on your behalf. The defense doesn't have to prove anything. Anyone who's accused of a crime or an offense doesn't have to be called to testify and is not required to testify. Does everyone understand?
Yes.
And what the law is that you can't consider the fact that someone decides not to testify. Does everyone understand that?
Yes.
And you cannot hold it against them in any way that they did not testify. Does everyone understand that?
Yes.
Now, many times people are like Mrs. Kravitz from Bewitched. You just want to know everything that people are saying. And it's okay to want to know that, but you can't hold it against someone for not testifying, and you can't consider it in any of your deliberation. Is there anyone here, if Mr. TOUSSAINT were to decide not to testify, would hold it against him? Okay. Is there anyone here? Because I'm telling you, you can't consider it at all. Is there anyone here who would consider it? All right. Now, we do have something in the United States called the presumption of innocence. How many people have heard of that? So what that means is when you're charged with an offense, you're presumed to be innocent. And you're presumed to be innocent unless or until the state, in the criminal world, the state proves their case beyond a reasonable doubt. And they have to prove each element beyond a reasonable doubt. Does everyone understand that? So as Mr. TOUSSAINT sits here today, he's presumed to be innocent. Does everyone understand? And right now, the state has presented no evidence to you, no facts, nothing. So at this point in time, if you were to give a verdict right now, your verdict would be not guilty. Does everyone understand why that would be?
Yes.
And that would be because the state has not presented any evidence at this point. Does everyone understand?
Yes.
All right. Now, I want to talk to you about burden of proof. When I graduated from law school, there was a definition for the burden of proof that the state is required to prove, and that's proof beyond a reasonable doubt. Had to learn it backwards and forward. And if you didn't know that definition backwards and forward, you felt like the world was going to end. Had my first trial in 1997, knew that definition backwards and forward. After my first trial, there's no longer a definition for proof beyond a reasonable doubt. So there is no definition of proof beyond a reasonable doubt. Does everyone understand? Usually what people will tell you is what it's not. I've been a defense attorney and a prosecutor. So usually they'll tell you that it's the highest burden that we have in our system, and it is the highest burden. You have preponderance of the evidence, and that's usually the burden that's used when it's involving civil matters, maybe fender benders, things of that nature. And then you have another burden that's higher than that, and that burden is called clear and convincing evidence. And clear and convincing evidence is used on the civil side as well. It's normally used when it involves the government seeking to take away your parental rights. They're saying that you're not a good parent, that we're no longer going to allow you to be a legal parent to a child. Does everyone understand? Now, that burden is still not higher than proof beyond a reasonable doubt. Does everyone understand? Now, in Texas, there are two phases to every trial. There is what people call the innocence phase, but really what the phase is, it's guilty, not guilty. And that's the phase where evidence is presented to you and you make a decision on whether someone is guilty or not guilty. That's the first phase of a criminal trial. If you find someone not guilty, then the trial is over with. But if you find someone guilty, then the next part of the phase of the trial is called the punishment phase. And the punishment phase is just what it means. It's where you determine what someone's punishment will be. Under Texas law, a person who's accused or a defendant must decide prior to jury selection and prior to trial whether or not, if they were found guilty, they would go to the jury for punishment or to the court for punishment. Does everyone understand?
Yes.
And when I say court, I mean the judge. So in this case, it would be me. So in this case, Mr. TOUSSAINT has decided if he were to be found guilty, that he would come to the court for punishment. Does everyone understand that this is not Mr. TOUSSAINT saying, I'm guilty? Does everyone understand this?
Yes.
This is just the law that says you must make a decision on if you were to be found guilty, where you would go to for punishment. Does everyone understand?
Yes.
Is there anyone here who's going to hold it against Mr. TOUSSAINT because he is elected, if he were to be found guilty, to come to the court for punishment?
No.
Now, I want to talk to you about the one witness rule. And I'm going to give you a hypothetical. And when I give you this hypothetical, don't try to add different scenarios. This is the hypothetical. This is the one witness rule. It could be any type of crime that's alleged to have been committed. You have one witness. That one witness comes in and testifies. You're sitting on the jury. You believe what that witness is saying. So there's no issue with that witness's credibility. You believe them. That one witness proves the state's case, every single element. So don't bring into the fact scenario, but was it dark? Was it in the morning or was it in the evening? That's not a part of this hypothetical. The entire hypothetical is the state brings one witness. You believe that witness. That witness proves the state's case. So that means every element the state has to prove, that one witness does it and you believe them. Now, again, this is a hypothetical. This is not about this case involving Mr. Toussaint. So the question is there anyone here, if there were only one witness brought and you believe that witness, there's no issue with the credibility, that witness proves the state's case beyond a reasonable doubt. Is there anyone here who would say, well, yeah, they proved the state's case beyond a reasonable doubt. They proved every single element, check, 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 check. I'm still going to say not guilty because I want more than that one person. Is there anyone who feels that way? All right, you need to raise your numbers. All right. So let me start over here. All right, and before you raise your numbers, lower your numbers for a second. I want to let everyone know that your country only asks one thing of you. They don't even ask you to vote. You don't have to vote if you don't want to have to vote. You don't even get drafted anymore. My uncle was drafted in the Vietnam War. And he actually went before he was going to be drafted. He just had my grandmother sign for him because they were drafting everyone in Grand Cane, Louisiana, small little town in Louisiana. So he went ahead and did that. So now you don't get drafted anymore. So your country is asking one thing for you, and that one thing is to serve on a jury. You can't have a good jury system if you don't have jurors. Does everyone understand? So we're going to go back to my hypothetical. So is there anyone who will still say, yeah, I'm going to need more than just one person? All right. That's number 6, 22, 36, 37. And after I call your number, you can put it down. 47, 49, 61. You're a little bit upside down in your number, but I'm assuming you're 61, 63, 70, 71, 72, 73, 74, and 75. And number 61, you can put your number down. And we have number 42. All right. All right, and this is the other question that I decided I have to start asking. Now, mind you, I think people who speak more than one language is absolutely fabulous. It's absolutely beautiful. When I hear the different languages and you pick up the rhythms of it. I'm a French speaker myself. I had a chance to learn any language and I chose French. So you can tell I didn't know I was going to be in Texas, but that's okay. So is there anyone who English is not your first language and you've had some difficulty following what I have said so far? Is there anyone who feels that way? All right. Now, the next question. Is there anyone who has any type of time constraint? And when I say time constraint, this is what I mean. You're leaving tomorrow on a jet plane, as the song goes. Your tickets are non-refundable. You can't give them to me. Is there anything similar to that where someone has a time constraint? All right. All right, are you number 9?
Yes.
All right, what is your time constraint?
My son's graduation,
All right, when is your son graduating?
graduating on the 20th.
That's May 20th? All right, thank you. Number 29?
My time constraint is this Friday. My time constraint is this Friday. I leave on vacation to California with non-refundable tickets through Tuesday.
All right. And what are you going to be doing in California?
Yosemite National Park.
Do you really want to see that? Isn't that going to be there later? Is it going to disappear?
I want to escape this Texas heat.
Okay. All right, watch when you get there. It's going to be hot, I guarantee you. All right, thank you. Number 12.
I also have a graduation on the 20th.
All right, which place is this? Who's graduating?
My younger daughter from UT Austin.
Oh, that is awesome. All right, thank you. Number 18.
I have a funeral June 18th.
All right, thank you. I'm sorry to hear that. All right, who else? 17.
I the best man at the wedding on May 20th.
All right, do they need you there? I mean, isn't there
I
someone,
think he won't be there.
are there other groomsmen though?
I think there's a few, but I think that's, he wants me there.
Okay, number 15.
15th weekend, I have a daughter's wedding.
A daughter's wedding?
Yeah.
Oh, wow, why is it taking place? I'm sorry?
Nothing, you know, you can send her here.
Oh, okay. All right, I'll try to stop by. All right, number 27.
I have 2 doctor's appointments on the 7th. I have 2 doctor's appointments on the 7th.
All right, June 7th. All right, thank you. All right, number 31.
My son's having a dental procedure on Friday.
Oh, what's happening on Friday?
He's having a dental procedure. He has had for a couple of weeks ago on Saturday. On Friday.
Okay, how old is your son?
15.
Oh, well, I hope he feels better. All right, number 36.
I have 3 grandchildren that I watch during the week. They do school online, and so I watch them during the week, and it starts next Monday for 2 weeks.
Okay, next Monday. Are you making them do all their assignments?
I do, I watch them.
All right. You know, my favorite book from childhood is still Chitter Chatter the Squirrel. All right, thank you. Number 34.
I have 2 daughters at dentist appointments tomorrow afternoon.
What time? 2:30?
Yeah.
Is there someone else to take them?
No.
All right, thank you. Number 42.
I leave out of town on Thursday, coming back on Sunday, and then have a doctor's appointment next Wednesday morning.
All right, so you're leaving on Thursday?
Yes,
Where are you going?
Florida.
What are you doing in Florida?
Seeing my
Come on. I'm saving you. All right, thank you. Number 46.
I'm due on the 4th of July.
Oh, you're having a 4th of July baby?
Yes.
Oh, congratulations. If anybody doesn't remember your baby's birthday, you need to just swipe them off. Number 50.
I'm going to Belize next Thursday and come returning on Monday, late Monday.
All right, thank you. 54.
My son just graduated from basic training and is shepherd at the base. I've made arrangements to meet his son.
Okay, so you're trailing off. I can barely hear you.
I've made arrangements to move their stuff in the house.
All right, so when is that happening?
Friday.
Friday?
And a doctor's appointment on the 18th.
Okay, all right, thank you. Number 58.
I have a military service this weekend.
Oh, wait, oh. All right, okay, thank you. Number 62.
I'm gonna be out of the country from the 19th to the 23rd in Panama.
And that's May 19th.
Yes,
Okay, what are you doing in Panama?
the group's been at a bachelor party.
See, he's just the groomsman. I don't want to say just.
I'm sorry, I meant best man. but-
He doesn't even have his duties down. Do you even-
I was just told recently, you have to choose somebody.
See, you know, I don't know if he should, that groom just choosing people on the last minute. All right. Okay. Number 70.
I'm going to hearing tomorrow in Bulgari. I have a court case hearing.
Okay, do you have, just tell them. I'm sorry, could you repeat
I
that?
have a court case hearing in Bulgari, Texas tomorrow at 1 p.m.
Tomorrow at 1 p.m.
Yes, ma'am.
And who's the dog you brought with you?
Oh, his name is Ollie. He's my support dog.
Ollie?
Yeah,
Is that a boy or girl?
boy, 6-year-old.
Okay, Ollie is 6. How old is that in human years, they say?
I hope he lives a long time, but maybe 40.
Okay, oh, please, he has a good 15, 20 years in him. All right, juror number 73.
I'll be in Dallas over the weekend for a family event.
All right, thank you. 74.
Non-refundable plane tickets to Williamsport, June 9th through 13th.
All right, thank you. All right, so everyone, I think you've got a chance to hear from yourselves as well as from the state and the defense attorney and Mr. Toussaint. Does anyone know any of those parties? Do any of you know anyone on the jury panel other than you just met them downstairs today? There's nobody who works with each other or teacher, student? I think this is the first time we've had a jury where no one knew each other. We usually have, at least one time we had the wife and the ex-wife on the panel together, but they were friends, so that was okay. All right, so what is going to happen now is I'm going to turn it over to the state and the defense. The state is going to get a chance to speak with you. And before I turn that over, I'm going to tell you a true story. This is not a hypothetical, this is a true story about me. So I have my friend who is a civil attorney, and she always wanted to do civil work. I always wanted to do criminal law. So we sort of got out of touch. We never saw each other much. We would talk on the phone occasionally, and she said she got called up for jury duty. She's like, "You want to do lunch?" And I'm like, "Yes, let's do lunch. We haven't seen each other in forever." So of course we get back together. It's like no time has parted since we were in law school. And I'm like, "How are you enjoying jury selection?" She's like, "It's awesome." I'm like, "Wow, never had somebody say it's awesome." And she's like, "I'm not going to get selected." And I'm like, "Why do you think you're not going to get selected?" And she said, "Because it's like when we're in law school, I'm on the back row, I'm quiet, not saying anything." And I started laughing uncontrollably. And she's like, "What's so funny?" I'm like, "You're so getting selected on that jury." And sure enough, she did. So for some reason, when you don't speak, you end up being selected on the jury. So other than saying, "Please pick me," the quickest way to get on the jury is to remain silent. So with that being said, I'm going to turn it over to the state, and the state and the defense will both have 40 minutes.
Hey, Karen. Good afternoon, everyone. First of all, thank you for coming in. I know that this is definitely probably the highlight of your week. It will be. And so, who, when they got their jury summons in the mail, thought this? Right? Very few have people excited to have a jury. But like the judge said, it's one of the few things that you're required to do as a citizen of the United States. And like the judge said earlier, the more you talk, the more we learn about you, the more likely you're probably going to be able to make the jury do some reason or not. So we encourage honesty. So what I like to talk about first is what it means to be a juror and what are the qualifications. So who knows who this is? Get a lot of cards up. I'm gonna pick on somebody. Juror number 4. Face the line. Right? You're just looking to get picked on, right? Who is it?
Willie Nelson.
And what does Willie Nelson love? It's in the picture. Marijuana, right?
No, yeah.
So Willie Nelson loves pot, right? He makes it pretty well known. I think he's even smoked pot on top of the White House. So is Willie Nelson necessarily going to be a good juror on a potentially marijuana case? Probably not. He's not making my jury for sure. It's because he disagrees with our law. It's not that he can't, follow other laws. It's just that he says, "You know what? I know that there's laws in the state of Texas about possessing marijuana, but I just don't believe in it." And he continues to possess marijuana. But who doesn't love Willie, right? That's why I like to use him as an example. Does that mean Willie Nelson wouldn't be a good juror on a murder case? No, right? Doesn't mean that he doesn't disagree with those laws, but he definitely disagrees with our marijuana laws. And so that's part of what we need to know from you today. We're going to explain a lot of the law to you. I'm going to ask if you understand it, and then I'm going to ask if you can follow the law. So if you don't understand the law, then you can ask me questions, and hopefully I can be able to work through that. But if you just don't agree with the law, I need to know that as well. And if you can't follow the law, I need to know that as well. This is the few times you get to argue with an attorney and win. My husband likes to think that too. So I like to think about this as an equation as well. What is a fair and impartial juror? Whoa. Well, it's a secret. Here. Let's see. Okay, it's that. So it means that you are able to follow the law that the judge gives you, and you base your decisions only on the facts of this case, not some facts of some other case you might know about or some personal experiences, but whether you can take the law from the judge and apply those laws to the facts of this case and then render a true verdict. Does that make sense to everybody? And everybody agrees that you've done? Yes. Is there anybody who will not agree with you? So like the judge says, and she's been a prosecutor, so she knows a little bit of my spiel. We were in a court together years ago, so she's probably heard this before from me. Beyond a reasonable doubt. We can't tell you what it is, but I like to explain it in some ways of what it is not. So it is not beyond all doubt. It's not 100%, and possible doesn't always mean reasonable. So, is it possible that an alien species we've never heard of invaded somebody's body and made them commit a crime? Maybe, right? You can't say it's impossible. Is it possible? Maybe. Does that mean that it's reasonable? Getting some shit, right? No, I think it's pretty fair to say that it's maybe possible, but not necessarily reasonable. So your doubt has to be reasonable. And that reasonable doubt, it has to apply to the elements of the offense that we're going to go about, talk about just in a second. So if you have maybe a reasonable doubt whether a witness is wearing a blue shirt or a red shirt, but every other element you believe beyond a reasonable doubt, then that doesn't mean that you haven't, that person would not be guilty, right? So long as you find every element beyond a reasonable doubt, then the verdict is going to be guilty. Does that make sense to everybody? I like to explain it because I have dogs, and so I think a lot of people do. And so this probably, unfortunately, is a real life example for a lot of us. Who here owns dogs? Where are you going? Who has come home to a scene several words with this? You're number 14, if I'm used to it. Sorry. So you come home with a scene like this. What happened? You started off the dogs, right? So you weren't there to see it happen, right? But you knew that there was a dog that had it, right? So this just proves to show you that you can know beyond a reasonable doubt that something happened and not been there to see it happen. Does that make sense to everybody? Kind of going back to that reasonable doubt, and if it's possible, doesn't mean always it's reasonable. Maybe is it possible you have a neighbor who really loves just to go in and throw some trash around in your house and then leave and not steal anything? Yes. Does that mean that it's reasonable? No. I kind of beat this one to death, so I'm gonna move on. So again, like the judge said, we're here for interference with a child custody case. So these are the elements that the state has to prove to you beyond a reasonable doubt. That on or about a certain date in Harris County, Texas, the defendant intentionally or knowingly take or retain a child, knowing that the retention violated the express terms of a judgment or order disposing of the laws of the child's custody. A lot of things that are really not ever disputed on these types of cases, like dates, that there might be an order that happened in Bear County, Texas. The big one on here is going to be that the taking or retention violated the express terms of judgment disposing of the child's custody. So, just a couple things on this. You can see that on intentionally or knowingly, the state has to prove to you one of those beyond a reasonable doubt. So let's say you make the jury There's gonna be 12 of you who are gonna decide whether the defendant is guilty or not guilty. So 6 of you could say, well, I think he did it intentionally. And then the other 6 could say, I believe that he did it knowingly. So long as every single one of the 12 believes at least one of them happened, who was either intentional or knowingly, beyond a reasonable doubt, then that element has been proven by the state. Does that make sense?
Yes.
Does anybody not understand? And the same thing applies to taking and retaining. So you can take 6, believe, I think he took the child. 6 can say, I believe that he retained the child, and kept the child. So long as each and every one of the 12 believe in one of those, then that would be the statement that element. Make sense, everybody? So, talking about intentionally or knowingly just for a second. Intentionally means it's the conscious objective or desire to engage in the conduct that causes the result. These are legal definitions. I'll break them down for you in a second. Knowingly is aware that the conduct is reasonably certain to cause the result. Like I said earlier, so long as the state has proved one of the beyond reasonable doubt, we met our burden. So you can see that a lot of this has to do with what is in the defendant's mind, right? Whether he did it intentionally or knowingly. How might we know that somebody did something intentionally or knowingly? And remember, the judge talked to you earlier about the defendant's right to remain silent. Right? So if he doesn't have to tell you, how might you determine if somebody did something intentionally or not? Sorry. Okay, you can please stand readily yell at me. A pattern, right? So you might see a pattern. So you've seen it before, and so if they keep doing it over and over again, you can kind of infer from it that they're doing intentionally. Anybody else?
Intentional acts. Intentional acts, things that have been documented in the past.
Okay, it's like a history of it, right? Sure, number, it's on the 42, can you see me?
Please stand up.
Can you see
Excuse
it?
me,
If they had signed some sort of legal agreement.
Right, so you might actually see a signature or acknowledgement of something, right? Right, and so a lot of this is you're gonna have to infer from the facts of the case and the words and actions of the parties, right? You're not, it's rarely that we see a case that says, you know, a defense can tell, well, I intentionally or knowingly did this, right? That's the only way you can go into his mind and know what happened for sure, right? But we can infer a lot of these things from the acts, right? So if I throw something at you, right, and it hits you, without me telling you, I'm going to knowingly throw this at you, intentionally throwing this at you, and hit you, you can infer from my conduct, right, that I intended to do it. Look at it and I throw it right at it, right? I would never do that. Right, and you can't read somebody's mind. So, you know, obviously, this offense involves some civil matters, right? Because, like we talked about earlier, there has to be an order disposing of the child. That's a fancy way of saying there's an order, a civil order in place that says where the child should be and where and when they should be there. Make sense? I know from some of your cards you've been divorced, some people have been divorced, so many of you may have been through this already. So, you know, people have strong feelings one way or another, especially if they've been through these types of things. So this is one of a couple scale questions that I'm going to give you, and it's a quick way to get a snapshot. And this is a good way of also practicing on these problems. So the statement here is interference with child custody is a civil matter and the state should not get involved. So you're gonna have to choose one of these four. You can't say I'm in between one and two. It's kind of like a pregnancy on this. We gotta get you down to one answer. It's not kind of pregnant, or pregnant or not. So you have to be 1, 2, 3, or 4. You have to choose one. So again, the statement is interference with child custody is a civil matter and the state should not get involved. There's 4 options. Number 1 is you strongly disagree with that statement. Number 2 is you disagree with that statement. Number 3 is you agree with that statement. And number 4 is you strongly agree to that statement. One more time, interference with child custody is a civil matter, and the state should not get involved. Who falls into category number 1? If you could raise your cards for me. Okay, I see number 12. And you can put your cards down when I call your number. 16, 35, 36, 37, 49, 70, and 75. Did I miss anybody? Who falls into category number 2? Disagree. I'm going to go 1, 3, 5, 6, 7, 8, 10, 11, 14, 15, 17, 19, 21, 22, 23, 26, 29, 30, 33, 34, 39, 40, 41, 42, 43, 44, 45, 46, 47, 50, 54, 55, 56, 57, 58, 62, 63, 64, 65, 67, 8, 69, 71, 72, 73, 74. Thank you guys. Did I miss anybody? All right, next after you is agree. Who falls in category number 3? I have 4, 9, 13, 20, 25, 27, 28, 31, 32, 38, 52, 53, 59, 60, and 61. The last one I have for you is 4, strongly agree. 18. All right, I didn't miss anybody, right? I have no idea number 1 I called, to be honest. So couldn't tell if I missed your number. Moving on. So we're going to talk about witnesses. Obviously, the state has to prove the case through witnesses. So what I want to talk first about is credibility of witnesses. The judge is going to give you a convicted jury. You're just so lucky to spend some hours with us the next day or 2. That you are to be the exclusive judge of the credibility of the witnesses and the weight to be given in their testimony. It's a fancy way of saying you can tell if somebody is, you feel like they're telling you the truth and they're telling you a lie, or maybe somewhere in between, telling you some truth and some lies. So, what types of things do we look at in determining credibility of witnesses? We do this every day when we talk to our kids, our spouses, our coworkers. What is that? 27?
They don't look at you when they're talking.
Okay. Look at you, eye contact. Right? 32. Let's see.
Their appearance and the way they dress with their parents.
Okay. 42.
Body language.
Body language. Okay. Anybody else? 73. You see.
The relationships of brothers being faced with charges.
Right. So they have some type of connection with one other witness or party. All right, those are all good answers. And so here's just some things that in doing jury selections I've heard before, and some things that I even personally look at. The demeanor, right? How they acting on the stand. Do they look nervous? Probably look a little nervous on the stand, but is it uncontrollable? Motive. I think juror number 73 talked about this a little bit, right? Do they have a dog in the fight, right? Is there a reason they might be saying something or not saying something or saying it a certain way? What they say, and this is kind of just, does it really make sense what they're saying? You know, does that story make any sense? Is it logical that it would happen that way, or does that make sense in order of events? Does it really make sense just generally? Right? And is there consistency in the statements? Maybe they give a previous statement. Is that consistent with their other statements? Right, and so I want to talk about consistency of the statement. Who here, we just got quite written names. Yes, was in March. I'm probably saying tradition, but it's been COVID's been too long. I can't remember when yes was. Okay. So who went to any the parade this year? I used to go to the Battle of Flowers parade every single year without fail. My aunt would take me, and they would my kid would always pick up church chicken on the way, not one of the things have changed since then. Thank God for my waistline. But great memory that I haven't seen. So let's say you go to the parade, and you go with the parade. You're both sitting in very kind of similar seats. You see the parade, you see everybody go by. I always look for the A&M band, being down with the A&M, my home band. I always gonna look to see if that A&M band is there, and remember that. So you watch all of it, and then after the parade, you talk to your friend. You say right next to you, who thinks that y'all are gonna remember the same floats or same bands that the person sitting right next to you? I see a lot of head shaking there, right? So you might remember a certain float or some certain shoes, right? Show me your shoes that one of the Duchess is wearing, but the person next to you, sitting next to you, might not remember those exact same things, right? Because you might be looking for something. Something might have stood out for you in particular. Does it mean that y'all weren't at the same parade? Right? So is it fair to say sometimes there might be inconsistencies, but it doesn't mean that either one of them is not telling the truth? Does that make sense to everybody? Does it not make sense to anybody? Okay. So who thinks if I told somebody, let's say I come back to work and I call my partner Michelle, hey Michelle, I love this float, this float, this float, this is the order the floats were in, blah, blah, blah. If I try to remember and tell her that same story, let's say even 2 months later, do you think I'm going to remember the exact same thing, exact same order? No, right? That memory might fade. I might remember something in a different order. Does it mean that I didn't go? Does it mean that I didn't witness it? No, right? Does it mean that I'm not being truthful when I tell her the story maybe 2 or 6 months later? No, right? So there might be some inconsistencies there. And so I just like to explain this in the sense of sometimes there might be inconsistencies in some testimony, some evidence, but it doesn't necessarily mean that somebody's not. That's ultimately up for you to determine. Again, if you make this sure, you are determining the weight of the evidence and the credibility to be given every witness. Does that make sense, everybody? Does anybody have any questions on this? So, in this hypothetical, you have to be robbed. I'm sorry, there's no choice. Because I used to always do something like, well, I choose not to be robbed. That's not a choice. You have to be robbed. So, who, if you had to be robbed, would rather be robbed on the picture on your left? You'd rather be, okay. And then who would rather be robbed on the picture on your right? Okay. I see most of the cards. Why is juror number 1?
Because there might be no witnesses.
Right? I think Memorial Stadium holds, I think, over 100,000 people right now. I would love if I was robbed, if we happened in front of like 100,000 people, to be on camera and all of those things. I'd rather not be robbed in an alleyway where there's potentially no witnesses, no camera, or anything like that. So does that make sense, everybody? And do you think that's how most of our criminal cases actually happen, and how what we're able to prove?
No.
Yeah, right. You know, unfortunately, most of our cases, you know, we're stuck with the evidence that we're given, and ultimately, it's who that determines where a crime happens and when it happens. We're going to say the defendant, right? The person who committed the crime, they get to choose when they did it, where they did it, who was around. Is that fair to say? They may disagree with that. It's okay to disagree. So I'm going to skip a little bit, but I'm going to go back. So I'm probably going to beat this to death, but I'm trying to hopefully everybody understands. Sometimes it takes a couple times for people to really, they might not want to tell me. They don't quite get it. So here's another example. So in this example, you also have to get mugged. I know you've been a lot of crime victims today, but I'm sorry. So let's say you are leaving today. You're obviously distraught because you didn't get to make the jury. And so you're going back to the garage. You're going to your car. There's nobody around you. Because you kind of just sat around here for a little bit, just kind of very melancholy about the fact that you won't be able to come back here for some time. So you go to the garage, and this is Bear County, it's county property, so you know none of the cameras are going to work. And so you get to the garage, and then you get mugged by your car. There's obviously no one around, there's no witnesses, there's no video. Who thinks that case should get dismissed? Right? You're robbed, right? You deserve some justice. Is it your fault that nobody was around? Is it your fault that there were no cameras? Is it your fault that you didn't pull out your cell phone and know that this guy or woman was going to attack you and try to report them? No, right? And so ultimately, this is most of the cases that we're talking about. Judge touched on this a little bit earlier. I'm going to do it in a little bit of a more nuanced way, and it's not quite the same question. Like I said a little bit. This is what we did earlier. There's 1, 2, 3, 4. So the statement here is if only one person testifies, that is not enough to find someone guilty. The options are 1, strongly disagree. 1 witness is enough if believable. 2, disagree. I will decide based on the testimony. 3 is agree. I want more. 4 is strongly agree. I need more. So again, the question is if only one person testifies, that is not enough to find someone guilty. Who falls into category number 1? Strongly disagree. We're at number 44. Who falls into category number 2? Disagree. 1, 3, 4, 7, 10, 11, 12, 15, 16, 18, 19, 20, 23, 25, 27, 13, 28, 29, 30, 31, 33, 35, 39, 40, 41, 42, 43, 45, 46, 48, 49, 50, 53, 54, 55, 56, 57, 58, 59, 62, 63, 64, 65, 7, 9, and 70. Falls in category number 3. I want more. 5, 9, 14, 17, 21, 26, 32, 34, 52, 60, 61, 71, 73, 74, 75. Default's better than 4, strong group. 6, 22, 36, 37, 47, 68, and 70.
What was 70?
70. All right. So next thing we're talking about is, Judge, how much more time do I have left?
You have a total of 12 minutes.
Comments? On my good time. Next thing we're talking about is evidence, right? Say that's through the case through evidence. Evidence. You're gonna get when you if you get selected to the jury, the judge is going to tell you in the charge report and the law report testimony is evidence, right? So repeat after me. Testimony is evidence. So you're going to hear a lot of people that tell you different things, and so that is evidence for you to consider in determining whether the defendant is guilty or not. You're going to do all those things we talked about earlier. You're going to determine the credibility of them. You're going to determine what weight or how much you're going to believe that witness is saying. But regardless, that's still evidence in this case. So, what type or kind of evidence would you expect in these types of cases?
Phone records?
Phone records. Number 37. You were really excited. I don't want to let you go. No, 37. I don't really want to hear this now.
From a therapist?
From a therapist, okay. Jury number 35. Other family members. Jury number 32.
Signed documents.
Same documents, right? You might get evidence of the actual court order that disposed that child custody, right? Jury number 3.
Anytime communications back and forth, text messaging, things of that nature.
Okay. Jury number 4. Camera footage. Maybe, right? Okay. Is there anybody who needs, let's say, a particular piece of evidence, like we get phone records or video? I need that particular piece of evidence before I find somebody guilty on this side of the case. Any particular piece of evidence? Jury number 7? Okay. Jury number 68? If you could see it from me.
Okay, sure. I don't have children, and I've never been pregnant. Happily married though. And I guess for me, just listening to everything, I just figure this is more of an emotional type of case. So it's like I'm already, and maybe I'm ahead of the game, but I keep thinking, maybe somebody did something. Yes, it was in writing. You're not supposed to do this, but if there was for fear of the child, I can't be hard on it. I would need more evidence. I would need more witnesses.
Okay.
I need something more than just because a piece of paper says this. There's always meaning behind why something was done, good or bad. And I guess I watch too much TV too.
I mean, it's a thing, but I doubt it's too much, right? Education, sure. Does anybody agree with how jury number 68 feels? Maybe you raise your cards.
Did they watch on TV too?
I watch a lot of TV, right, so. All right, I have jurors numbers 1, 4, 5, 6, 7, 10, 13, 14, 17, 20, 21, 26, 27, 28, 29, 33, 34, 35, 36, 41, 42, 49, 50, 52, 53, 55, 56, 57, 58, 60, 61, 62, 63, 71, and 73. I was going to say this earlier, but I'm just going to jump into it right now. Is there anybody here who feels that this should not be a crime. Juror number 4. 13. Does anybody feel that this should not be a crime? When we went over those elements of the offense, Michael, even if you prove me beyond a reasonable doubt, those elements of the offense, I still don't think this should be a crime. This is the Willie rule, right? You get to disagree with the law. I just need to know whether that's the case. Number 6, 21, 36. Yes, you can say it.
So. I forgot, I'm sorry.
Okay.
I'll
Keep thinking on it. Turn number 64.
Could you just define again what were you referring to from the nice
Sure.
lady behind me?
Oh, what was she was saying?
You asked who agrees, I wasn't sure who you agreed with. Emotional, she said it was.
Well, I mean, is there any part of it you agree with?
Mike, you're standing in front of her again.
If you can see
So
it.
should I raise my hand if I think it's?
If you think it's emotional. She had a lot of things about, please correct me if I'm mistaken, that it's hard to say when there might be a reason that they might not be doing it, and it becomes a lot of emotion, and they may be doing it for other reasons. Whether it's their concerns about the safety of the child, things like that. Okay. You get them, Jeff? All right. Going back to,
Sorry. Can I clarify?
sure.
Prior, not this one, but the question you'd asked, if anyone else felt like this shouldn't be a crime. I'm not saying it's not a.
I didn't say.
Okay,
No,
let me
no, no.
clarify that. I mean, it can be, but at the same time, I think it's possible that there's, to me, there's just always that possibility when you only have one person who's going to give their part of it, depending on how strong it is, you might be able to make a decision, or for me, I would be able to make a decision maybe on that. But again, because I don't have children, but I just assume, I mean, it's a tug of war.
That's fair. And the question I was asking was not in relation to what we said. It's just, I was kind of moving ahead because we were talking about the line, it's thinking emotional. There's some people who think that this just shouldn't be a crime. State shouldn't get involved. And so I just don't believe this should be a crime. I think I had Juror 4, raise your card. Anybody else feel that way, that it should not be a crime, the state should not be prosecuting the second case? Juror number 6. 13. And 15. I didn't see that. There's how much time do I have left? I'm sorry.
4 minutes and 29 seconds.
All right, I'm gonna go to my final questions. Is there anybody here who's not sitting in judgment of another person, whether that's religious or racist? Juror number 6. At 5, 6, 9, 17, 22, 60. 5. Juror 5. Is that, you raised your card, correct? Is that a religious, moral reason? Okay. And what is your particular, I guess, religious belief?
I'm basing it on what I read in the Bible. But I'm sure there's something, I know that there's a law, but I guess I look at myself and I think, you know, not the middle for a law, but I would want to be.
This all applies to you, just raise your cards. So this is saying that, you know, maybe religiously, I don't think I should judge people, but this is to say the judge is going to give you the law and tell you that you have to follow the law. And this is to say my religious beliefs do not allow me to do what the judge tells me to do. Is to take the law, apply the facts to the law, and then render a verdict based on those. Is anybody unable to do that based on religious and moral reasons? Raise your cards. 6, 9, and 17. And 6. Does anybody here who's been know anybody who's been accused of this crime? not 8. At this time, 4 and 37.
I would say the answer is no, but based on what I do for a living, I do I'm in this a little bit.
I understand what you're coming from. I'm picking up what you're putting now. And I said 58 too. Does anybody who knows something who maybe did on the other side, or a victim of this? Juror number 6, 37, and 75. Is there anybody who did not sit at this jury trial for any reasons that the judge didn't already talk to you about? Health issues, hearing issues, language issues that we should know about. Is there anybody here who believes that they cannot be a fair and impartial juror on this case for reasons that we have not already talked about? Jurors number 6 and 9. Juror number 6, you mind telling me?
He had, well, first, I am one of the Bible cases first. But on a side note, we knew somebody who was involved with the mother had custody. She was abusive, but the law had given her custody. The law was wrong in that situation. So I don't know his situation here, but for me to find him guilty would be extremely hard. I'm not one to sit here. I mean, sitting here, I heard that, and I don't know the case.
Okay.
So it would be very hard for this one.
So based on your prior experience in the legislature, we would think be there. Juror number 9.
So I had, was very unfairly prosecuted by the president. And I believe in the justice system. I don't believe in the way it's either got.
Okay. Was it particularly this type of offense or is it not?
No, but I do know somebody.
So based on your experience with your father, you do not believe you can be a fair and impartial judge. Anybody else? All right.
I'm sorry, Sam. I just went through the same thing.
I'm almost out of time. Hopefully, we'll have, if anybody has any questions for me, I'll go the other.
Sorry, please go back to Jason's talking about the one, with this rule.
Mhm.
I don't remember what that was.
Sorry, I'm out of time, guys. I would love to, but we talked about it, I think that we got the names from you, but the defense will be able to base their decision for you. Thank you, guys. I appreciate your time. Thank you.
All right, so everyone, we're going to take a brief break so we can give Brenda a break and you all can have a break. These are the rules. One person leaves the courtroom, you all must leave. So no one can stay behind and say, well, I don't have to take a break, so I'm just going to stay in the courtroom. So everyone must leave. And everyone needs to be lined up outside by 3:30. So in the words of Paper Chase, look to your left. Look to your right. Remember the person who's next to you and make sure that they're in line at 3:30 and you're in the 187 District Court, okay? All right, everyone, please rise.
Please the court. Ladies and gentlemen of the jury, good afternoon. All right, awesome. Okay. So today it is my honor and privilege. My name is Shannon Locke, and today with Kim Gonzalez, it's our honor and privilege to be defending OTIS TOUSSAINT. And he is a veteran, government service worker with the Surgeon General of the Army. Does anybody know OTIS? Anybody met him? Okay. So today we're going to be talking a little bit about divorce and child custody. Two of the most, contentious parts of our society. Who here has either gone through a divorce themselves, a child custody dispute, or knows somebody who has, like somebody close to you? Okay. Because the questionnaire was like everybody's married, and so I'm like, that's okay. It's okay. Don't keep your cards up. You gotta keep your cards up. Okay. All right. So so lots of you know about divorce and child custody firsthand. Okay, and I'll let you know that I've been divorced, and my kids and their mom are no longer together, and through a child custody thing. And put the cards down. Thank you very much. I know I told you to keep them up. Cards down. And a couple things. My current wife and I run a law firm. Okay, I'm a criminal defense attorney. I'm a board certified criminal defense attorney. I've passed the bar in 2 states. I think of myself as kind of a smart guy, right? Okay. Whatever. But I passed the bar in 2 states, board certified criminal defense attorney. My wife and I get together. My wife does criminal law. My wife does family law. Okay. And if anybody knows things, criminal law is kind of fun. Okay, we get to do this stuff, right? We get to talk to people, we try cases, and it's fun. Family law is not fun. Okay. It is horrible. Okay. And so my wife and I are getting together, we're getting this law firm together, and she's like, hey, I've got a great idea. How about you do some family? Right? I'm like, great, that's great. I'll do family. Right. So we meet with a client. And the client says, I want sole custody of my kids. Dad is terrible. He's getting herpes. It's awful. Okay. So I want sole custody of my kids. And I said, that's great. We'll get it done for you. Okay. So we're in court. Yeah, I'm going to get this woman sole custody of her kids. I said, what are you going to do? Yeah, I'm going to sole custody of her kids. I said, you can't. That's not how this works. Okay. Just because I was a board certified criminal defense attorney, I wasn't not a very good family law. Okay. It was totally different. Okay. In fact, when I look at my own child custody agreements, okay, it is almost like it's written in Chinese. I have a hard time reading. So is anybody like aware of these child custody agreements and had experience with those child custody disputes and how that goes? Yeah, number 71, number 64, 23. I'm just gonna, people who've had some experience with it, if you could just raise your cards. So 3, 18, 27, 23, 31, 34, 37, 39, 47, 59, 58, 3, 2, 7, 4, 71, 75. All right. So I'll tell you just a little bit, just to give you some more background. In Bexar County, there's a standard possession and an extended standard possession. And in an extended standard possession order, the non-possessory parent, the parent who doesn't have primary custody, okay, gets kids on every Thursday and the first, third, and fifth Fridays of every month. Okay. And so that seems pretty straightforward. You always count by Fridays, and people always forget that. You always count by Fridays. And so the fifth Friday of every month, as I'm sitting at our brand new law firm, what happens? Everybody starts to call, right? Because every month doesn't have 5 Fridays. And so people get confused, right? Does that make sense? Okay. So all of our clients are calling. He's not giving back the kid. She's not taking it. I'm supposed to have the kid. No, I'm supposed to have the kid. No, I'm supposed to have the kid. No, I'm supposed to have the kid. And everybody's sitting there trying to figure out who's supposed to have the kids, right? Okay. Are those people committing crimes? They're not. Why not? So you're shaking your head there on number 35. Tell me why. Why do you think they're not committing crime?
Because they're clarifying expectations.
Okay. All right. So they had the order, right? It's right in front of them. And I've gotten very good. This part I can do. Okay. This family law part I can call in. Like, hey, have the kids. All right. Let's take a look at your order. You see the part where it says, you know, extended standard or regular standard. Okay. Let's go. Let's look at the calendar. What Friday are we on? It's the 4th Friday. You do not have it. It's the 5th Friday. Yes, you do have it. But is that person committing a crime? Do you think? And you're shaking your head no. Let me see your number, man. 58. So tell me why not.
It's just a misunderstanding.
It's a misunderstanding, right? It's a misunderstanding. And so what are they doing? These law-abiding people who have court orders, but in misunderstanding, what are they doing?
They're clarifying.
Clarifying and calling their lawyers, right? Okay. Now let's say I screw up. Okay. Let's say the poor person on the other end of the phone doesn't get the family law lawyer, she gets the criminal law lawyer, and the criminal law lawyer says, yeah, sure, take it, right? Okay. And gives bad advice. Okay, whose fault is that? It's the attorney's, right? Okay. That's bad legal advice, right? But what if there's a dispute? Okay, let's say the order is not clear. Okay, what happens then? Anybody know? Go ahead.
I can't see you or hear you.
So, yes, number 7?
You can't appear.
Well, not yet. All right, let's pump the brakes a little bit. Number 3, yes, sir. You should return to the court to clarify the order. All right, you should go to court and say, hey, all right, so my lawyer says one thing, their lawyer says another, right? Let's call the police. Yes?
I said, go back to the court.
You're saying go back to the court, right? Don't call the police yet, right?
I didn't think we're at police yet.
We're not at police yet, right? Okay, we're not at police, okay? Hey, I get the kids on the 5th Friday. Yeah, but it was the 4th Friday. I was counting by Saturdays. Yeah, you should count by Fridays. Okay, guess what? We're gonna go back to court, right? And there's a whole separate branch of the law, right? Okay? It's the civil side, right? It's not criminal. Nobody gets, well, you can't get put in jail for civil violations, but it's a civil part of the courts, right? Number 3? Yes. Okay, so at that point, right, if there's a dispute about what the order is saying, okay, and guess what? In a dispute, especially about child custody, both sides are absolutely sure they're right. Okay, right? They're absolutely sure they're right. Okay, and guess who you're having this dispute with? Your favorite person in the whole world. Who is it? Your ex, right? And so number 73, when you were talking about motives and relationships, right? Okay, so guess what, right? Who has a motive and what kind of relationship is that, right? Okay, does that make sense? Yeah. Okay. So there's this whole other side of the law. It's the civil side, right? And you get to say, look, this isn't going well. Okay, we're disagreeing about this. Okay, and what the judges on the other side, the civil side, will do is they'll look at the best interest of the child. What we were talking about, number 64 and 68, the emotional component of it. Okay, they have this whole factor, the best interest of the child. All right, and they say, okay, you know what? And then the best interest of the child. That's why I was being. My wife was so upset with me. Okay, when I was ready to give the wife sole custody of the kids because her husband had been terrible and given her herpes. Right? They're like, hold on a second, Shannon, that has nothing to do with the kids. All right. So those are the factors that have the best interest of the child. And the civil courts will go through these best interests of the child and make a determination about who's right. Okay. And if you continue to violate, right? Then you are knowingly and intentionally violating. It's more than just a misunderstanding. Does that make sense? Yeah. And that's how we end up. That's how we would end up here on a case that is justified. So here, the state has the burden, okay? They have the burden to prove beyond a reasonable doubt. All right. Everybody get that? Right? So I could just sit back and relax and force the state to prove its case beyond a reasonable doubt. I don't have to do anything. Is everybody okay with that? Yeah. Awesome. But I don't have to do anything, okay? The state has to prove its case beyond a reasonable doubt. They have to prove that OTIS here took and retained, okay, contrary to a court order, okay, and knowingly and intentionally took and retained contrary to a court order the child in question. Okay. And so they have to prove all of those things. Okay. And Mr. Villarreal said, well, dates aren't important. Dates are important. Okay. Because in family law, dates drive everything. Okay. Your rights on the fourth Friday are not the same as your rights on the fifth Friday. It's different. Your rights during the odd numbered Christmas days, Christmas years are different than your rights on even numbered Christmas years. It's the way it works. Okay. Does that make sense? Okay. So is everybody okay forcing the state to prove its case together? Now, it's also true, okay, that everybody wants to hear both sides of the story. Okay. All right. And how many people would agree that they want to hear both sides of the story? That's 1, 3, 4, 5, 6, 7, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 25, 26, 27, 28. I think it's everybody. We're just gonna say that. Okay. So we want to hear both sides of the story. But constitutionally, okay, constitutionally, somebody accused of a crime doesn't have to testify. Okay. Why do you think that might be? Why do you think that somebody who's not guilty, who's innocent, wouldn't testify?
They don't incriminate themselves.
They could incriminate themselves. That's one reason. Yes, sir. Any other reasons? Go ahead. They could be under pressure. They could be under pressure. Okay. Number 60.
Right to remain silent.
Yeah, the right to remain silent is very important. Why is it there? Number 74. Yes, ma'am.
So you don't unwillingly say something that can be held against you.
That's a great example. I had a client and she was accused of shoplifting, and I was pretty sure, okay, based on the limited evidence and everything that I saw, that she was innocent. She had this terrible tick where she would laugh after she said everything. So she'd say, "I didn't go into that HEB." Okay. I would say you gotta figure out how not to do that. I didn't take the toothpaste. And it sounded like every time she said something, she was like a pirate getting away with something. And it was ridiculous. And I said, look, I think that we have to say that you're just going to remain silent. Okay, because you could unwillingly, that jury's going to say, that jury would not be able to get past the fact that she sounded guilty, right? They have this preconceived idea, right? And that can be very dangerous. So does anybody have a problem if we remain silent during this trial? Anybody have a problem with that? Is that anybody gonna say, you know what? If he was really not guilty, you just get up and say it. Is anybody gonna say that? So the state has to prove beyond a reasonable doubt, and what they have to prove beyond a reasonable doubt is knowing an intentional violation of a court order. Okay, while taking and retaining your child. Okay. That's what they have to prove beyond a reasonable doubt. Okay. It's not a preponderance of the evidence. Okay. It's not 51%. It's not clear and convincing evidence. Okay. Not to take your kid away. It's proof that's stronger than that. It's proof beyond a reasonable doubt. Okay. Does anybody have a problem with that? Does everybody kind of get why that is? Right. So if you're pretty sure, okay, if you're pretty sure, yeah, I think that maybe he did this, right? Okay. But you're not convinced beyond a reasonable doubt, what's the appropriate verdict? Not guilty. Okay. Is everybody okay with that? So how many people involved in child custody disputes have felt like somebody has done this to them, that a child's been taken or retained away from them, well, the person knew that they were violating court order. Has anybody had that experience? Yes, sir.
Well, I mean, again, because of what I do, I deal with a lot of.
How about you do?
Huh?
How about you do?
I work at the juvenile detention center.
Okay.
I'm a residential support supervisor.
Okay.
So essentially, I deal with kids who are in some form of the juvenile justice system.
Gotcha.
So that's a lot of kids who are involved with child protective services, a lot of kids who are involved with runaway, anywhere from possession of marijuana to murder.
Sure.
And I deal with, my specific position, I deal with the worst of those kids who are in the facility. So I deal with the ones who are in security, who are always getting in trouble, who are always getting restrained, who are always in some sort of,
So you have a lot of personal experience with messy child custody situations.
Yes.
Okay.
And I get it a lot.
Physically beyond it. Oh, man.
I mean, it's a joke, but yes,
Okay.
we're physically involved with these kids a lot.
Right.
So
It's a hands-on experience.
yeah, so my experiences are basically with the individual child a lot. But I hear, I was with this parent, I had to go to that parent, and I want to run away and be with the other parent because the other parent doesn't do what I want to do.
Gotcha.
Same thing with child protective services. They run from those facilities all the time. They have criminal histories.
And so I'm gonna stop you a little bit, okay? And I'm just gonna pick up on a little something that you said. One thing that we're not gonna be deciding here, okay, is who the child should be with. Okay. Does that make sense? Okay. So this is not a civil proceeding where we're trying to decide who gets the kid, okay? That's not this kind of case. Right? Does everybody understand that? And in fact, we're not going to be talking, my anticipation, I don't think we'll be talking at all about those sorts of things. Okay, we're just going to be talking about knowingly, intentionally violated order or not. Okay. What about, let's say you're in a situation where you think to yourself, I've got this child custody order and I want to interpret it. Who do you call? Who's the person that you would call? Who says your turn? No. All right. Yes. Okay. Everybody ready? Okay. Good. Right. So you call your attorney, right? And then and attorneys, their jobs are to interpret these orders, correct? Yeah. Okay. And so when there's a dispute about the interpretation of these orders, then they go to a judge, right? And the judgment and the judge breaks those ties, resolves those disputes. Does that make sense? So I'm close to being finished. Is there anything else that we need to know about anyone? Because we are going to be talking a lot about divorce and child custody, and those are really going to be the emotional trigger situations. Is there anybody here that has a lot of experience with that, negative experience with that might bleed into this trial? Anybody? This is a good time to. Number 37. Can you tell us what's going on?
I'm a therapist and also a TOUSSAINT advocate, so.
Okay. So you see this a lot. You see a lot of negative situations. Do you think that those experiences might make it hard for you to be fair and impartial?
Yeah, there's one client that's been long-term that's going through like the exact same thing, and we actually have the trial that's starting tomorrow that I've been heavily involved with.
Okay.
With my vacations and
So you can't be fair and impartial in this.
don't think I could be.
All right, thank you. Number 18, yes, sir.
Divorce twice. Had child custody once.
Okay. Okay. So you feel like your personal experience would sort of lead into this?
I don't really know.
Okay. Okay. The question is, okay, can you be fair and impartial? Okay. Okay. So you force the state to prove the state's got a reasonable doubt? Sure. Okay, you wouldn't hold it against the suit to say decide not to testify. Presume him innocent? Okay. Until the until the state brings evidence to prove him guilty. Beyond a reasonable doubt. Okay. Anybody else feel like their personal experiences would make them? Yes, sir, number 4.
On my end, I mean, I can be fair. I'm an honest guy, but my ex would keep my kids from me all the time against orders.
Okay.
And I never took legal action because I wanted to make it worse for the kids.
Right.
So that's where I might be biased, but that's my.
Okay. So do you think that you could be a fair and
I
impartial?
think I can be
And do you think that you force the state to prove its case? Number 13.
I'm wondering if I wrote school. I'm recently divorced and my daughter was like 17, going to 18 at the time. And we had the schedule of like when she was shorter with it out and everything. And we actually kind of made a joke about it. And I was like, oh, no, you're supposed to go with your dad's name. I'm not going. And it stayed at that.
Yeah.
Like we never followed the anything of it.
Okay, I got you. Do you think you're gonna be fair? Okay. And so, I mean, so they're, I understand what you're saying, okay? And it's one of the inherent problems in prosecuting these kind of cases, okay? Is that a lot of times people do it, okay? I will tell you, for instance, one of the things that always sticks in my craw, okay? Mother's Day, there's in the standard possession order, Mother's Day, moms get the whole weekend, regardless of who's, right? And Father's Day, the dads get Sundays that end at 6, okay? Like right as the barbecue starts, right? Okay. But guess what? You can make agreements, okay? And you can work with your spouse or whatever, or ex-spouse, and try to figure that out. But if, so who else feels like they may not be able to be fair and impartial because of their personal experiences? Because of anything that might be going on? Yes, sir, number 48.
I can't defer from my experience with my brother and the mother. It's just saying that it's always arguments. My brother's always working with mom. We're begging her to let us take her on vacation. So I prefer just saying my experiences when I see it going through.
Okay. Okay. Anybody else have anything similar? That they want to tell us about? This is like our only opportunity. So if you're like, gosh, I think I'll talk to him in like 5 or 6 minutes, right? It's not going to happen, but we need to know. We need to know like right now. Okay. So anybody else? Yes, sir. Number 65.
I have 9 brothers and 5 sisters.
I'm sorry, stand up.
It's number 65.
I have 9 brothers and 5 sisters, and 5 of them have gone through divorce and got a similar situation like that. I also have one of my sisters. Can I be fair? Yeah, I can be fair, but you know, it's me, the fact that they've gone through it, I've seen it, that's how I've gone through it, but you know, whether I agree or disagree, I don't care.
Okay, and I think that we would expect you to keep an open mind so that you do hear it. Okay, so that we can so that you weigh everything independently. But does anybody have anything in their personal lives where it'd be like, you know what? And I was talking to somebody recently, and I said, the circumstance is, you know, they're basically using the criminal justice system to get advantage in the family life. She said, that's exactly what they said about me. And people don't do that. I was like, hold on a second, you're talking about yourself. You're not talking about this case. Okay. Does anybody feel like they have personal experiences that might come into this case so that you can't be fair? You wouldn't force the state to prove its case. Well, as I said at the beginning, today it is our honor and privilege to defend Ms. Rose to say this is the most important day, and we think it's going to go today, tomorrow, I think Thursday. Okay, and just the people who had scheduling conflicts for today, tomorrow, and Thursday, I think might be the longest, maybe Friday on the outside. Would anybody have like an inability to come to those 3 or 4 days? Number 42, 29. Okay, so I'm going to go through 9. I think we've heard enough from you. Okay. That's going on. I don't know. So no. Okay. So number 29. Just tell us again why.
Vacation, leaving on Friday.
To California.
Yes.
Okay, I think Friday, okay, it's Friday. So that's Friday, number 29, number 31. Dennis,
Yeah.
got it. Okay, number 34.
My two daughters, dentist appointment,
Dennis will come in also, okay. And that's like
2:30.
2:30 tomorrow.
I have a medical injury on Thursday.
All right, so the rules are that if you're not in the jury box and not on this front row, that people need to stand so that Brenda can hear, and that we do not block Brenda's view of those who are speaking because it makes it harder for her.
That was number 60, medication refill on Thursday.
Friday, military.
Okay.
I'm leaving on Thursday morning.
Okay. 49.
Without this appointment tomorrow, it's my event. I also take care of my granddaughter. And they are on to vacation day, so they.
Wow, okay. All right, so it's a necessary doctor's appointment on this one. Not
Yes,
required.
I was told it the first one to go today.
Okay. Okay. So an essential doctor's appointment.
Yes.
Okay. With a specialist.
Yes.
Okay. Number 54.
Yeah, I made arrangements with my son and his wife.
And when is that?
I'm sorry.
When would you be? Friday? Okay. Number 70, yes, sir.
I will go to you tomorrow in Woodwood.
You're on CF, okay.
I'll be out of town in Dallas over the weekend. I'll be Thursday night.
Anything else we need to know? Last chance. I'm done. I didn't even use all my time, did I, Jed?
Do you want more time?
No. I'm good. Thank you very much.
All right, thank you. So ladies and gentlemen of the jury, this is what we're going to do. Everyone who's in this box, well, really everyone, take all your personal items with you, but leave the expensive cards behind and wait for us in the hallway, and we will call you back to let you know who is on the jury panel. But everyone, please remove all of your personal items. Don't leave any personal items behind, and just wait outside for us.
And leave your numbers behind, please, thank you.
Oh, it is hot.
announcement as chair. There's a little surprise. Let me open the front.
All right, everyone, thank you so much for coming. We still have someone in the back of the room. It's standing room only. Everyone, please have a seat. All right, ladies and gentlemen of the jury, thank you so much for your service here today. Of course, as I said before, you can't have jury trials without jurors. So thank you so much for coming down. If you would like, those of you who are not selected on this jury, we can have you come back tomorrow to serve again. Let it marinate. Don't immediately say no. All right. So as I call your name, I'm going to need you to take a seat over in the box onto the side because you will be on the jury. Mark Herrera, Edgar Beltran, David Harvey, Diana Hernandez, Victor Carrion, Maria Sanchez, Marina Slavin, James Rosacker, Lauren Brock, Jessica Gall, Miguel Cifuentes, Eduardo Casas, and the alternates are Stephanie Torres and John Koetkin. How do you pronounce your last name?
Petkin.
Petkin. I missed it totally. So the O is silent?
Yep.
Okay. I was always taught when two vowels go walking, the first one does the talking. That's what
It's
you.
German, so.
Ah,
it's a little bit
okay.
different.
All right, thank you. All right, so all of the other persons, you will receive your excuse. You also have a document with you that you can make a decision to donate what you received for serving today. You can donate that to many organizations, or perhaps in maybe 2 to 3 months' time, you'll receive a check in the mail. It'll be a surprise to you and it will make your day wonderful and beautiful, but it's enough for you to have a great lunch, what you will receive, or you can donate that to many of the organizations that are looking for donations. If you need the validation for parking, you'll have to go back downstairs to the central jury room. Does everyone understand? All right, so don't be a stranger to the courthouse. It's a nice place. I hope you realize that it's not a scary place. And once you find parking, you can always see what's happening at the court. I believe it's very important to demystify the courthouse. So make sure you come back and visit us. All right, thank you. And say goodbye to Olive.
There's 2 of us. And there's some more. My partner has more of legal constitution and those excuses for work or school.
All right, and if everyone will please be seated. So, ladies and gentlemen, These are the certain rules I have for you. Number one, I have no control over the temperature in this courtroom. So make sure you bring a jacket or something with you. You're more than welcome to do that. Sometimes it's super cold in this courtroom. Sometimes it's hot in this courtroom. We just never know what we're going to get. If you want to bring something to drink, you're more than welcome to bring something to drink. Just make sure there's a cap on it so there won't be any spillage. We're going to start tomorrow at 9 a.m., but we can't start at 9 a.m. unless everyone is here at 9 a.m. When you report to our court tomorrow, you won't be going downstairs. You're reporting to this court. Deputy Laura will show you where you need to go. We have a jury room for you, and that's where you will meet. And you will meet there, and then we will call you in for court. I've had the docket moved, so this case will start immediately at 9 a.m. Does everyone understand? All right, so I'm hoping you'll have a good chance of finding parking, but what I can tell you is that everyone comes at 9 a.m. And as you know, jurors are here sometimes at 8 or 8:30. And so parking goes pretty quickly. So to be assured of parking, you probably want to be here well before 9 a.m. Okay? Does anyone have any questions? Yes.
So when are we meeting again tomorrow?
9 a.m.
Is it here or downstairs?
No. Don't go downstairs. You come upstairs. Deputy Laura is going to show you where to go.
Okay.
So you're going to follow her after I release you. Yes.
Tomorrow and Thursday? That was a good job.
Okay. I anticipate that we'll probably complete this case by Thursday. Now, that's just expectations, but sometimes things go awry and I have no control over that, okay? All right, and the other thing I want you all to be aware of, throughout the trial, you're probably going to see people coming in through this back door for me. I'm also presiding this week, so I may have officers who are coming to speak to me about different things. I may have attorneys from other courts coming to speak to me about different things, but none of that has anything to do with this case. So don't even consider it. Don't think about it because it's not related to this case. And if you see me looking at one of the computer screens, I'm not playing video games or anything of that nature. When Brenna types, I'm able to see what she's typing. It comes up on this screen. And then sometimes there are orders that I need to sign that people from other courts are sending me because I'm presiding. Any other questions? Yes.
Can we bring that tablet to take notes?
I don't encourage that, and I ask that you not do it. And the reason, and this is why, because when this case is given to you for deliberations, you're not allowed to refer to those. So it's best that you just pay attention to what's happening and listen to witnesses as they come. Now, the other thing, if someone is speaking and you cannot hear them, just let us know. If for some reason you can't hear the witness, let us know. If you can't hear the attorneys, let us know. If one of you needs to take a break at any time, raise your hand. Either I will see you, or either the defense, the state, or the deputies will see you. And lo and behold, Brenna, even though she has her back to you, she usually sees you as well before I do, because I have the screens that are blocking my view sometime. So just let us know if you need a break. Yes?
Hi, yes, I made it clear that I was leaving on vacation on Friday, and you said we should be done on Thursday. That makes me a little nervous.
Don't be nervous. There's nothing to be nervous about. Don't be nervous.
Okay.
Yes.
Okay.
So just make sure you just pay attention. I want to make sure that everybody who's on the panel pays attention to the witnesses and pays attention to what's happening, okay? Yes.
Whenever you were calling jurors names, somebody may cover this, but what does it mean when you say alternate juror?
Oh, that means that you still need to be here.
No, I.
Yeah. So we'll cross any bridges of what that means at a later time.
Okay.
Yes, but for the alternates, you need to listen to all the evidence as well.
Okay.
And again, everybody, all 14 of you need to be here for us to start on time. Okay.
I was just curious if there was a reason why you called them alternates as opposed to.
No, there's no reason.
Okay.
All right. The other thing is, I don't expect this to be a media coverage event or anything like that, or for it to be in a newspaper or on TV or wherever it may be. But if you do see something related to this case, you need to turn it off. Don't pay attention to it. Don't speak to anyone about anything regarding this case. Does everyone understand? And you're not to go out and try to do your own investigation. Let me see what I think could have happened or should have happened. The evidence that you receive to make decisions in this case will come from this courtroom. Do you all understand?
Yes, ma'am.
And when it gets to the point where I want you to deliberate, I will let you all know. All right, any other questions before I have you go back with Deputy Laura? All right, everyone, please rise. Yeah. All right, so everyone, we're going to be starting at 9 a.m. If there's any matter that needs to be discussed before then it needs to be discussed before 9 a.m.
Yes, sir. And I'm, as promised, I'm giving him copies of the body worn cameras that have been in the file.
All right, and is there going to be something that the court needs to view? And Brenda, you can be excused because I know you need to go where you need to go. Is there something that the court needs to view beforehand? Because as you all aware, I know nothing about this case. I hear the evidence as the jury hears it. So if there's going to be an objection to some video or something that's being entered, then I will need to know that beforehand.
I haven't seen the video, so I don't know yet. I would say generally, we have a long history between these two married people and a very specific allegation in the indictment. And so we're going to be asking that the evidence be limited to that allegation. And I think that's certainly something that the court needs to keep in mind.
Okay, but I'm talking about videos. Anything?
Evidence wise, potentially we might be offering one small portion of Sergeant Bettis's body worn camera video in regards to him speaking on the phone with your client's civil attorney. But it's not a very long clip from my recollection.
How could you tell me when it would be? Like,
I don't have the timestamp on it, but I can text you. Shane, if you want.
Okay, all right, so we're gonna be back here. You all need to be back here at 9. And if that's, Mr. Villarreal has my cell number. I know you have my cell number, and I know you have my cell number. If you all want to chat me with cell, if there's something issue that needs to be decided before 9, just include everyone in the text chain.
I'm only concerned about general 404B information coming in. There's a lot of potential for none of it disclosed, but I'm concerned about any of that coming in.
Well, there's no request either, so.
What do you mean?
You didn't request any 404B. No,
I mean,
so, if you're requesting it now, I can respond to it, but at this point, I
mean, we do have a motion limited on file.
Well, motion in limine will be taken up as it's presented.
So should we take that up before tomorrow?
No, because I don't know anything about this case. So what will happen is the state can call their witness. And if there's something in the motion in limine that you have an issue with, then the state can approach.
If they're gonna get into any prior bad acts.
I don't anticipate prior bad acts, but we have to talk about the orders that were in place,
Yes.
right? So, and we're gonna talk generally that they have a kid together, because that's the child. So I don't know exactly if there's anything specific you think that is in the discovery that you think I would bring up.
There's tons in the discovery that I'm concerned about child abuse.
All right, so I'm gonna be back at 9 tomorrow. You all have my, where you can text me if there's an issue.